Hey, it's Christine Faulkner, Elk Grove estate lawyer, Sacramento Living Trust attorney. Thanks for tuning into another edition of The Daily with Christine. Today I wanted to talk about what happens when you have a trust and your assets are not correctly titled or you don't have a beneficiary designation. So this video is for you if you've created a plan already, if you have a trust, maybe it's been a while, maybe you did it yourself and you're not really sure what, how titling plays a role in the success or failure of your plan. So let's get started. So when you create a trust, it's really important to understand that not only do you need to make sure that you have a trust, which lays out a lot of different information like who your beneficiaries are, when they're going to receive assets, how they're going to receive assets, but making sure also that the second and very crucial component of having a trust plan that works is that your assets are titled correctly, or that if you have beneficiary designations on certain financial accounts that you've actually been very intentional about naming beneficiaries. So what happens if you have a trust, and let's just take, for example, someone who's single. So when you're married, if one of you pass away, and something's not done correctly, then you still have time to fix it. Unfortunately, if you're single and you pass away, there is no time to fix it anymore. It's a done deal. So hopefully when you're creating a plan and you're working with an attorney, they've informed you about the importance of making sure that your assets are properly funded or titled to the trust. So for instance, you want to make sure that if you own real estate, that your real estate is held in your name as trustee of your trust. Now, when we work with clients, we do that for them at the time the plan is being created. We want to make sure that the deed is done. It's usually one of the biggest assets that people own, their real estate. So we prepare the deeds for them. So we know for a fact that has been done. But the rest of the assets, like bank accounts, investment accounts, retirement accounts, life insurance policies, some of them have beneficiary designations like life insurance and an IRA, for instance. And so important that you make sure that you have named the right beneficiaries, the people who you want to receive your assets, but also you've got a backup plan. So you have a primary and a contingent. That can be different depending on a whole lot of factors. And I'm not going to go into that on this video. It's too complicated and it's beyond the scope of this particular subject. But just know that if you have accounts that have beneficiary designations, you want to make sure that you have a primary and a contingent, so your backup plan. But what about the house that has a title? What about the bank account that has a title? What about investment accounts that have title and they don't have beneficiary designations? You want to make sure that those accounts and or that real estate is always titled in your name as trustee. Because if you have assets that are not correctly titled and you pass away, they're going to be stuck. And if they're over the probate threshold, either cumulatively or a single account is over the probate threshold of $166,000, that account is potentially going to have to go through probate. There is what's called a Hegstead petition, which is a petition to the probate court, which goes something like this. An attorney prepares a petition and gathers the evidence that would persuade a judge that although, say, a particular account was not correctly titled in the trustee's name, that the trustee intended it, the creator of the trust and the trustee intended it to be part of the trust because they listed it on an exhibit or schedule to the trust. There also has to be information in the pour-over will that confirms that. So are several pieces of documentary evidence that are important to be included in your planning if an attorney were to be successful with that petition. And the idea is that the attorney is going into court and trying to persuade the judge that the creator's intention was for this property to be in the trust, even though it was not actually titled correctly. And again, that is done through a paper trail of documentary evidence that the attorney produces as exhibits or evidence attached to the petition. If the lawyer is successful, then great. The judge issues an order saying this account is part of the trust, and that order is then presented to the financial institution, and the financial institution will then release the funds to the trustee. If you're not successful or the evidence just isn't there, then unfortunately that account or that asset will end up in a full-blown probate, which is expensive, time-consuming, and not ideal. So important that you be clear, if you already have a trust, just how important titling and beneficiary designations are. So the same thing will happen if you have an account with a beneficiary designation and that person has either passed away, so they can't accept that gift, of a life insurance policy or the remainder of your retirement account, or you don't have a beneficiary. The same result happens. You end up in probably a probate. Depending on the evidence, you might be able to do a Hegstead petition as well, but depends on the kind of asset it is and what the planning documents actually say. So it's so important that you make sure that you have a primary and a contingent beneficiary on all of your beneficiary designated accounts. Otherwise, the account is going to be frozen. Nobody will be able to access it. So if it's important to continue paying the mortgage and pay the bills, that account won't be available to do that. And of course, you can imagine what catastrophe might occur if those monies were actually needed to continue to pay a mortgage so that your beneficiaries could receive the home. So none of this, of course, addresses what happens when your trustees try to take care of this for you and the true headache and time-consuming maze they have to go through in order to get the assets. So let's put it more simply. You created a trust to simplify your life, to make things easy, beneficial, expeditious, and private for your family, for the people that you love who are going to receive your assets. And when there is an asset that is not correctly titled or not either funded, titled in your name as trustee, or there is no beneficiary designation, you're really shooting yourself in the foot. You've taken the time and invested money to create this plan, and it's going to be really unfortunate when even more money has to be spent and your assets are tied up in court because this one minor detail, what seems like a minor detail, turns into a major big deal. Could cost lots and lots of money. And the truth is, people create plans so that they can avoid probate. And it's so unfortunate when people have planning and they don't either understand about title and beneficiary designations, or they just never get around to it. They just don't do it. It can be catastrophic. And the entire reason for creating the plan can be completely, I don't know what the word is, overturned, right? Like it was almost all for nothing because, your trustee ends up in litigation, ends up in probate court anyway, just to get the asset. That all that had to be done was it had to be transferred to your name as trustee, or you name the right beneficiaries and you name enough beneficiaries. So this is so important. I work with clients on trust administration, so administering a trust after someone has passed away, and it's always such a hard thing to have to tell the trustee, unfortunately, you don't have any control over this particular asset at this time, and the best I can do for you is hopefully get through a Hegstead petition, which is still going to be time and money. And the worst is that if we don't succeed, then we're going to have to be in a full-blown probate. That's something nobody wants to ever hear after the principals, the clients have actually taken the time to create a trust. After all, that is the main reason people do it. So they can avoid probate, they can avoid court, and keep things simple and straightforward. So please, please, please be aware. If you have a trust already, go back and look at your assets and make sure that everything is properly titled, beneficiary designations up to date. If you haven't looked at this for a while, now is a great time to do that, to make sure your plan works for the people that you care about. Thanks so much for tuning in. Subscribe to our channel, like our videos, and let me know what you'd like to hear about. We're here to help. If you're in the midst of a trust administration, or you've had somebody that you just lost who had a trust and you're not sure what to do, please give us a call. We definitely can help you. Take care. Bye.